Hi, my name is Deb Mahaffey, and I'm a divorce attorney in Harrisburg, Pennsylvania. I also handle a lot of child custody matters. Today I'm going to talk with you about how to deal with a situation when the parent of your child tells you that he or she is going to be moving from the area that they currently live in. This is called a relocation case, and Pennsylvania law has very specific requirements for how to handle a relocation. If you're faced with a situation where the parent of your child tells you that he or she is going to move, you first need to sit down with a child custody attorney like myself, who can explain to you the law. Today I'm just going to go over a few points as to what Pennsylvania law requires if a parent wants to relocate their child. The first thing you need to do is identify whether or not you have a child custody order. If you have a child custody order, look at that order very carefully and see what it says with respect to relocation. If you have an older child custody order that was entered prior to 2011, you should consult with a custody attorney even though you can read your child custody order to find out if the current law is consistent with what is in that child custody order. Pennsylvania law requires that if you are going to move, you give notice to the other parent, and you have to do so 60 days before you intend to relocate. If you have an emergency situation or you had no way of knowing of the relocation, you can give notice in 10 days, but there are very specific requirements for that 60-day notice to be waived. Once you give notice to their parent, you have to do so with very specific information. You have to tell the other parent where you're moving, what school district you're going to be living in, and most importantly, you have to tell the other parent what your proposal is for changing the custody arrangement so that the other parent can still have access to the child. You are also required to serve the other parent with what's called a counter affidavit to give them an opportunity to tell you if they object to the move and if they wish to have a hearing to address their concerns with your proposed relocation. If the other parent does complete that counter affidavit and returns it to you within 30 days, you cannot relocate if they object. There must be a court hearing, and at that court hearing you have to prove to the court that it's in the best interest of the child for the relocation to occur. Relocation is a very tricky area of the law, so it's strongly advised that you meet with a child custody attorney who knows the relocation law. You can contact me at 774-1357 or go out to my website at www.heinemlaw.com to schedule a consultation so we can discuss your specific circumstances.